Hi, this is Camille Jasmine with today's Oceans of Opportunity. And yesterday I attended a wonderful legal update. I know that sounds so exciting to you. However, it's presented by one of our top California Association of Realtors attorneys, someone who I actually like, yes, an attorney that I like, because he is so great at converting the legalese into layman's terms and makes it fun and entertaining. So I thought I'd share some information that is pertinent to you as a buyer, seller, or an investor. First of all, we have a form you may have signed as somebody that has done a recent real estate transaction called the Statewide Buyer-Seller Advisory, acronym SBSA. Anyhow, that's about 10 pages long. And I found out that every time there's something new, kind of a stupid lawsuit that has a stupid outcome, that we add a paragraph to that form. For example, once upon a time, a buyer bought a property that backed up to a golf course. Moved into that property, golf balls were landing in his backyard, maybe on his head. Anyways, he decided to sue because nobody disclosed that to him. And actually he won. So now there's an extra paragraph in that document that says if you live near a golf course, this could happen. So anyhow, that's one example. Number two, you may have heard about this already, especially if you are in this situation. The government last year had stated that they were going to discontinue the Mortgage Forgiveness Act. So what that would have meant is if you owned a property, wanted to sell it, had to sell it for less, you could possibly be taxed on that difference as income. Well, the good news is that they have extended that Mortgage Forgiveness Act for primary residents only. So just make sure that you're aware of the restrictions on that. Number three, there's actually going to be a new disclosure on our purchase contract that says you can go to a website to look for pipelines below a certain house. Obviously, we've had legal action of things that have happened to cause that to be added. Kind of like our Megan's Law. Anyways, moving on for number four, for you FHA and VA buyers, on occasion, a second appraisal is required. If for some reason that second appraisal does not come in at the value and you've already removed your loan contingencies, you can still get your deposit back, even though you may have signed off on that. So there is protection for you. And lastly, we as realtors have been given some great sample letters that sometimes you, the consumer, may need. For example, if you're a buyer, you move into a property and the seller left personal items that were not negotiated or agreed upon. Are those items yours? What do you do with them? Well, first of all, they're not yours, and you have to actually notify the seller that they have 18 days to get them. Otherwise, you can sell them at a yard sale. There's a value there that must be about $700. There's a lot more detail involved in that, and that's why you have to not just leave your real estate questions to anyone. Just give me a call. Be happy to help you out. This is Camille Jasmine with today's Oceans of Opportunity. Have a great day.